Hi, and thanks for purchasing MSA 101, a brief tutorial on Medicare Secondary Compliance as it pertains to workers' compensation and liability insurance. This course is powered by BMA West. I'm Gus Ortiz, president of BMA West. In this short tutorial, we'll discuss the Medicare Secondary Compliance statute, the history surrounding it, how to better identify it, and the consequences for not complying. So let's talk a little bit about Medicare Set Aside arrangements and the history surrounding that. The Medicare Set Aside arrangement was first introduced as a compliance mechanism in a 2001 CMS memorandum. Please note that CMS stands for the Centers for Medicare and Medicaid Services. In that same memorandum, it was recommended that a Medicare set-aside arrangement be the recommended method for considering Medicare's interests in an insurance settlement. The adequacy of this arrangement would be approved by CMS in order for the parties to finalize and rely on the arrangement itself. However, it should be noted that the Medicare Secondary Statute does not compel the parties in an insurance settlement to have their Medicare set-aside arrangement reviewed by Medicare, also known as CMS. BMA West and many other Medicare secondary statute providers highly recommend that you do have your Medicare set-aside arrangement reviewed by CMS in order to avoid future litigation or the expenses related to said litigation. So what is Medicare Secondary Compliance? Well, here's a story. Back in the 1980s, a few of our congressional leaders were standing around smoking in the hallway, casually discussing how the Medicare system was going broke. It seemed that people were living longer, and it also seemed that there was a leak in the system. They were losing money. Maybe a few years later, they figured out that they were losing millions of dollars every year by paying future medical claims related to workers' compensation and other lines of insurance. Ultimately, they created the Medicare Secondary Compliance Statute. And in a nutshell, that statute asserts Medicare's position as a secondary payer whenever a primary payer is responsible for the payment of health services. What that means to us as claims adjusters is that Medicare does not want to pay for your injured worker's injury, and you will have to set aside funds in a separate account so that the injured worker can pay his own medical treatment after you settle the claim. The Medicare Secondary Payer Statute says that Medicare will not pay for services to the extent that payment has been made or can reasonably be expected to be made promptly under any of the following lines of insurance: workers' compensation, liability insurance, and no-fault insurance. Maritime insurance can also be included in that list. Federal law takes precedence over state law and private contracts. In other words, Medicare may invalidate any settlement if it does not consider Medicare's interests. So what are the consequences of noncompliance with the Medicare Secondary Payer Statute? Well, for the claimant or injured employee or plaintiff, if you may, he's at risk of losing Medicare benefits for future injury-related care expenses. He or she may lose Social Security benefits, which may be offset in order for Medicare to make recovery of conditional payments. A conditional payment is a payment made to a medical facility by Medicare on behalf of the injured party, knowing full well that there is a primary payer in the picture. However, In most cases, the primary payer does not know that Medicare has made this payment and will not know until settlement becomes an issue in the case, at which point Medicare will seek to recover their payments as a conditional payment. Noncompliance for a primary payer, in other words, an insurance carrier, a third-party administrator, or a self-insured employer, well, there's unknown exposure for conditional payment recovery and the potential for double recovery by Medicare. It's also possible that Medicare will force them to reopen their case after the settlement is completed in order to recover those conditional payments. For a defense attorney, there's also an exposure to malpractice for failing to protect their client's exposure for failure to comply with a conditional payment recovery. So fast forward, and today you are a claims examiner handling a workers' compensation desk, and part of your skill set requires you to have at least general knowledge of the Medicare Secondary Payer statute. So part of your skill and part of your repertoire of skills requires you to develop a protocol of when to start looking or when to identify or how to identify a case requiring this type of compliance. Well, let's start here. When does a person become Medicare eligible? Many folks don't know. In fact, probably your managers don't even know that 6 months after a date of injury, a disability began for the claimant, and he is now at this point eligible to file for Social Security Disability Insurance, SSDI. Not to be confused with state SDI. This is Social Security Disability Insurance, a facet of Social Security and Medicare. After 24 months, the claimant becomes Medicare eligible. So after 24 months of Social Security disability, this individual, no matter what his or her age, is now eligible for Medicare. Medicare eligibility can happen for a number of reasons, this being one of them. Now, before we go on, I want to talk to you a bit about CMS review thresholds. Now, there are hundreds of Medicare secondary compliance companies out there, and each one of them, in their attempt to market their companies, have managed to confuse claims examiners across the country. Many claims examiners and their managers are under the false belief that if an insurance claim does not meet the CMS review threshold, then Medicare does not need to be considered in the settlement. This is completely incorrect. For the record, please note that Medicare needs to be considered in every settlement, in every workers' compensation or liability or no-fault insurance settlement. Medicare needs to be considered. Okay. How you consider them in cases that do not meet the CMS review thresholds is completely up to you. However, please do not think that these thresholds are a safe harbor in order to avoid considering Medicare. Please note that CMS review thresholds are a workload threshold for CMS, for Medicare, and not a safe harbor to avoid Medicare consideration. These thresholds were established by Medicare because they were receiving way too many cases that they were not humanly possible to attend to. It started at $10,000, but now the new threshold is over $25,000. Medicare should be considered in all settlements where future medical benefits are settled. Never use these thresholds to determine your obligation to CMS. So these are the CMS review thresholds. If you're a claims examiner, you need to be aware and you need to identify when you're dealing with a Medicare beneficiary. Okay. Once you identify that you have a Medicare beneficiary in your caseload, you need to ascertain whether this settlement will reach the thresholds. Okay. The individual is a Medicare beneficiary at the time of settlement, and the total settlement amount is greater than $25,000. Okay. Medicare does need to be considered in those circumstances. So what I'm saying to you is that once you reach a point of settlement and you find that your injured employee is a Medicare beneficiary, and that case will be settling for more than $25,000, then a Medicare Set Aside arrangement will be necessary. Okay. Now that $25,000 includes permanent disability advances, any remaining permanent disability due, any kind of incentive amount that you'll be adding to the settlement, and the amount of future medical care money that has been projected in a Medicare Set Aside arrangement. You add those up, and if it's over $25,000, then Medicare needs to be considered. Now, if you happen to have a claimant who is not a Medicare beneficiary at the present time, that individual can settle above the $25,000 amount. However, if the claim is over $250,000 and there's a reasonable expectation of Medicare entitlement within 30 months of settlement, then Medicare should be considered in that instance. Okay, so I know that's a little bit confusing. Some companies label these as Medicare threshold classes. Class 1 being the Medicare beneficiary with the case settling over $25,000, and Class 2 being a Medicare consideration for a non-Medicare beneficiary, where the individual's settlement will be over $250,000 and he can be reasonably expected to be on Medicare within 30 months of the settlement date. It takes a while to get that, but just keep studying that, and feel free to call us at any time if you have questions. So those thresholds usually bring about the big question of identifying reasonable expectation for Medicare eligibility. Okay, and I'm talking specifically about that Class 2 designation of the CMS thresholds. So identifying reasonable expectation for Medicare eligibility would include when a claimant is receiving Social Security disability benefits at the time of the settlement. If the claimant has applied for Social Security disability benefits or has applied and been denied, but is anticipating appealing their denial, that would also qualify. The claimant is in the process of appealing or refiling for SSDI, or the claimant is age 62 and a half or greater at the time of settlement. And then finally, if the claimant has end-stage renal disease, that would definitely qualify under these thresholds. As a claims examiner, you likely have many different protocols that you follow in the office. However, in my experience, I have yet to find an insurance carrier or third-party administrator that has established a Medicare set-aside protocol for their claims examiners. So let's talk about that. Your first step in your Medicare set-aside protocol would be to identify potential Medicare eligibility in your claimant. So you would look for signs of eligibility, such as the age of your injured worker, the amount of time that he has spent off of work. If it's more than 24 months, it's very possible that he is receiving Social Security disability insurance, and that would make him Medicare eligible. Um, it's very possible that he's receiving other government benefits. Um, the injured worker may have applied or may be receiving SSDI. You may also look in the file and find an old Medicare letter from CMS, or a letter labeled MSPRC, which is a recovery letter in the file. That would indicate that this injured employee is in fact Medicare eligible. It's important to know whether the injured worker has any other illnesses or injuries. Fortunately, in 2010, the MMSEA Section 111 statute required employers, third-party administrators, and insurance carriers to report their entire caseloads to CMS in order to identify Medicare eligible claimants. Okay. This should help in identifying those claimants in your caseload. All you need to do is ask your manager or supervisor for a report of the MMSEA Section 111. If you see your injured worker's name on that list, then it's very likely that you need to consider Medicare in a settlement with. So another part of your Medicare Set Aside protocol would be to notify the claimant that you're looking to find his Medicare eligibility. So you would send him release forms, which would be provided by a Medicare Secondary Payer provider like myself to you. You would send to him a copy of a HIPAA release, a Social Security release, and a CMS consent form, all of which he would sign and return to you. You would then provide those forms to us, and we would search out his Medicare eligibility through Medicare. As we approach the end of your protocol, this next step would require you to obtain a Medicare Set-Aside arrangement from a Medicare secondary provider like myself, BMA West. Prior to entering into settlement negotiations, if too much time has passed, I would recommend that you revise that Medicare Set-Aside arrangement in order to identify any new medications or any new medical services that have been included into the employee's medical regimen. Okay. You would also want to provide us with updated pay histories for indemnity, medical, and prescription lines, as well as a tentative settlement document or estimate. Okay. And once we have all that material, along with a full copy of medical records, we would send the proposed compromise and release along with the Medicare Set-Aside arrangement to Medicare for approval. Once approved, the claim can be finalized with your local workers' compensation judge. Once a settlement has been finalized and a settlement order has been issued, you would provide that to our office, and we would send it to Medicare for closure of their file. The entire Medicare secondary payer issue and obtaining a Medicare set-aside arrangement, it can be lengthy. If a claims examiner is not prepared, and if they had not obtained signed releases or medical records as is necessary, then the process can take even longer. Okay. It's very important to keep medical records in order and to ensure that all your medical history is properly accounted for. Okay. I hope that this tutorial has been helpful to you. I cannot stress to you enough the importance of having a Medicare secondary compliance protocol in place in your company, and as a professional, having a Medicare compliance protocol for yourself. Having a methodology to follow in this compliance issue will save you time. It will save you considerable expense in litigation. You'll find your ability to use a Medicare set-aside arrangement for valuating your claims to be very important. And it will also give you a better idea as to the value of your claims overall. Coaching you to effectively utilize and understand Medicare set-aside allocations is our primary purpose. Supporting you in using the MSA to move your case closer to settlement is equally important. So we commit to you our accurate, timely, and affordable Medicare set-aside arrangements. But we also, and more importantly, are committed to your success. Thanks again for sharing your time with us on this tutorial. You're invited to contact us with any questions you might have, and we welcome the pleasure of working with you. Now, I know that this tutorial is rather short because the Medicare Secondary Payer Compliance Statute is a very complex issue. This tutorial is simply meant to provide you with an outline and an idea as to what compliance is about, what Medicare set-aside arrangements are, and how you can implement them in moving your cases closer to settlement. If you have questions, feel free to give us a call or contact us via our website. Thanks a lot, and thanks for tuning in. I'm Gus Ortiz, President of BMA West.